Welcome to Rights of a Free People, a program of the Rhode Island affiliate of the American Civil Liberties Union. I'm Dan Weissman, a volunteer at the ACLU and host of this program. It is late spring, early summer, so it's time for a Supreme Court wrap-up. And this year, the Supreme Court has been particularly busy in the area of civil liberties. So we're going to do two programs, one this month, one next month. This show will look at the Supreme Court cases that did not involve immigration. Next month, because that topic is so complex, we'll take it on as a separate show. So with that in mind, let's introduce our guests who have been involved at the local level in the cases we're going to examine. Starting closest to me, John Marion, the Executive Director of Common Cause in Rhode Island. Thanks so much.
Oh, thanks for having me.
And I think this is a repeat visit for you, so no rookies this time.
Yeah, no, we've been here talking about voting rights for years in the past, and we'll, I'm sure, be here again.
It's not going away.
No.
And Richard Sinapi, who could chair this program, has been doing it as a guest as long as I've been moderating the program. Dick is from Richard Sinapi, Esquire, in Warwick, and just an old friend. And good to have you.
Thanks. Glad to be here.
Excuse me?
Glad to be here.
Me too. Well, I wish we had more good news. And we may not totally agree what's good news, what's not. I tend to be a little depressed by this Supreme Court session. But let's get into it and see how this works. We want to start with the case, maybe of the five we're going to look at, that got the most ink and maybe the least understanding. And that's the Masterpiece Cake Shop. Tell us the story, Dick. What happened? Where was this? What were the particulars, and what did the court tell us?
This case is very interesting, and it cuts across civil liberties protections in different ways. In the first instance, this is a decision where the Colorado Civil Rights Commission ruled that a baker, actually a business that refused to design a cake for a gay couple, had violated the Colorado public accommodations law. Now, we all know public accommodations laws. They've been around since, 1964 Civil Rights Act. They provide that you cannot, in a business that's open to the public, you cannot discriminate on numerous grounds of protected class individuals: race, color, sex, creed, age. Of course, sexual orientation has been added of late. Both too many state public accommodations laws. I don't think it's been added to federal yet, sexual orientation, but it has in Colorado. So the Colorado, Human Rights Commission had no problem saying, hey, you violate the public accommodations law. You are discriminating against people because they're gay and you won't do their cake. It's a violation.
So these people had gone into the Masterpiece Cake Shop and said, make us a cake, or please make us a cake. And they said no.
Correct.
Because we disagree with same-sex marriage.
I think he mentioned religious belief. It's what the individual mentioned. Offered to say I'll sell you anything you want. I just won't, make a same-sex couple cake. That went up to the Colorado Appeals Court, which unanimously upheld it. The Colorado Supreme Court denied review because they felt it really wasn't worth it. This was a, blatant violation of the Public Accommodations Act. So I think the same Hobby Lobby, narrow, limited interests, funded this big appeal to the U.S. Supreme Court. And the U.S. Supreme Court, in a rather lopsided decision, most people don't know, is actually 7-2, reversed the decision below and held that it was not a violation of the public accommodations law to prohibit, to refuse to make them a cake because of the religious beliefs of the business, basically. Now, that decision has three components. Well, first of all, that decision can be viewed as, well, geez, it vindicates, free exercise rights. It vindicates, free expression rights. So it's a good thing, because you're not imposing upon this business. On the other hand, you are, violating and, again, stigmatizing, a protected class of individuals, people on the basis of sexual orientation. So this decision has three components: a practical one, which is just horrendous; a doctrinal one, which they avoided; and a decisional one, which thankfully, I believe, is narrow. As a practical matter, it's a horrible decision, because if you interpret public accommodations laws with these kind of loopholes, I can say, well, you can't come in my restaurant if you're a woman unless your head is covered. Well, because it violates my religious belief, but you can't do that. It offends me. You can't come in. You have to have something on your head. And if you're a person of color, you can come into my restaurant, but you got to sit in the back because, like, my religion, you don't believe as me, and you look different, so you have to go in the back. Well, I've got a sincerely held religious belief to that effect. I should be able to do that as well. As a practical matter, it's a horrible, horrible decision, and that's why Hobby Lobby is so bad. But that's worse because it lets elites impose their political beliefs on all their workers. I mean, their religious beliefs, but that's beside the point.
Well, remind us, Hobby Lobby, what was that decision?
Hobby Lobby was the case where it said that a corporation has religious beliefs, and that corporation's religious beliefs are such that it can refuse to comply with the state's compulsory insurance law and opt out of, birth control for its workers as part of it, the rider, of course, of health insurance. And again, I don't know how a corporation can have a religious belief. I think it's offensive to allow elites who own a business to impose religious beliefs on their employees, but that's beside the point. So this is like another Hobby Lobby extension, although I don't believe it was mentioned in this case. Now let's look at this from a doctrinal standpoint, why it was so bad. Because the doctrinal standpoint is very simple. This is the Smith test. It used to be the Sherbet v. Werner free exercise test. Very simple, three components. Is this a neutral law of general application? Part one. Of course it is. It's a neutral law. It's not aimed at anybody in particular. It just says you must treat everybody equally in a public accommodation. Okay. Two, does it materially impair the practice or free exercise or beliefs of somebody's religion? Well, arguably, he says it does, but let's move on. Again, I don't know how a corporation you can impose on their beliefs, but that's beside the point. Then you go into the third one. Under the Smith test, it's all you need is a rational basis to support that governmental rule of general applicability, a neutral law of general applicability. And here it is, you want to protect the rights of disfavored class, of a protected class, and you want them treated equally, and that's good enough for a rational basis. So it would pass that test. Interestingly, it was Scalia who changed that from a compelling governmental interest test in Sherbet v. Werner to the Smith test, because it involved the case involved peyote. But in any event, so applying that simple doctrine, you avoid problem one that I talked about, the practical problem of somebody raising those beliefs and then infringing upon the rights of everybody. So applying that doctrine, this person still would lose. What the court decided on was a narrow basis. It didn't say that the religious beliefs were not overruled by the rational basis of the governmental restriction of having free public accommodations, free from discrimination. It said that the Colorado Human Rights Commission did not properly apply and consider whether or not they had sincerely held religious beliefs that prohibited them from serving these people, okay? They said, and they cited to a whole bunch of things, the way the hearing was conducted, some other precedents where they allowed people not to serve people who had hateful or discriminatory cakes or practices that they wanted the business owner to promote. And they said, because of that, we're going to say they didn't get a fair hearing. And rather than remand it, so it's been 6 years, we're just going to reverse this case, and say that it's based on religious beliefs, you can't enforce it. In doing so, they invoked a case, the seminal case that nobody ever cites, of the Church of Lukemi Babalu I, which was a case down in Florida involving Santarians, where the local land use board gave these Santarians a hard time in getting appropriate approvals to construct their church. And in that case, they said that based on the conduct of the board's hearings, their statements, what they did, their rules, that they really were hostile to their beliefs. And that's why they didn't give them the land use that they deserved. And by the way, I think the Supreme Court was right in that case. They did. However, they invoked that in this case where, as I said, it's pretty clear cut. You apply the three-part test, you're not going to pass the Smith test. I think that this restriction should have been applied in this context, and I told you all the practical evils if you were to allow business keepers to release, oh, my free expression, oh, my religious belief, to refuse to serve individuals in a protected class. So it was a horrible decision. It has very horrible practical implications. However, the good news is it was decided on a very narrow basis, a process basis, that the process by which the Human Rights Commission determined that they violated the law by not considering whether they had a sincerely held religious belief. It was decided against in favor of the shopkeeper. So because it was decided on that narrow basis, I think there's some hope.
Okay. And when you've been mentioning protected class, that's typically groups of people who are historically discriminated against.
Right.
That's what so they're not special in the sense of privileged. In the law, they're recognized as particularly vulnerable.
That's the best way to put it. They are particularly vulnerable politically, economically, and subject to discrimination and exploitation. And the whole purpose of our laws is to integrate everybody into our society, our great society. And so that's exactly correct. It is not to favor them, it's just to prevent others from disfavoring, discriminating, and exploiting.
Good. Let's move on. We have 4 other cases, and I think they're a little more straightforward. John Husted, this is Ohio?
Yeah, correct.
Ohio. So this is a voting rights case.
Yeah, and so this deals with 2 laws. It deals with the National Voter Registration Act, which is people know as the motor voter law that was passed in 1993, that requires all DMVs across the nation to offer the opportunity for people to register to vote. And it's not a case about a constitutional principle, it's a case about statutory interpretation, about how that law is written and how the Ohio Secretary of State interprets that law. It also deals with a later federal law on voting rights called the Help America Vote Act, which was written in 2002 and passed in the wake of Bush versus Gore, and made some minor changes to the motor voter law, the National Voter Registration Act. And it's about a part of that motor voter law that deals with how to keep voter rolls clean. So many people are familiar, if you want to register, or if you want to vote in the United States, in every state except for North Dakota, you have to register. Some states allow you to register the same day, but you have to register nonetheless. In registration, rolls are very tricky to maintain because many people move and they register at a new location and they don't unregister at their old location. So, for instance, Rhode Island really has more registered voters than it does adults who are of age to register because of that. And every jurisdiction has this problem. So when they wrote that law in 1993, the federal government said that states should take reasonable efforts to keep the voter rolls clean so there aren't people who've moved or died on the voter registration rolls who have moved or died, to keep the voter rolls from becoming too bloated. But there's some language in there that says you can't use the fact that you didn't vote as the only reason someone can be removed from the voter rolls. So people might not be familiar, but it's a matter of public record whether you voted or not. Not who you voted for, but whether you voted or not. And the National Voter Registration Act, the Motor Voter Law, allows, after 2 federal elections, for you to be removed if you didn't vote. But that can't be the sole reason why you're removed. There have to be other reasons why. So the Ohio Secretary of State has a rule of removing people, and really the primary reason why they're removed after 2 federal elections is the fact that they didn't vote in those federal elections. And so they were challenged by the A. Philip Randolph Institute in Ohio, claiming this violated the National Voter Registration Act as amended by the Help America Vote Act. And that really it has to be part of a number of factors. It can't be the primary factor for removing somebody that you didn't vote. So it was decided 5-4. The conservative majority said, no, Ohio's interpretation is acceptable. They believe that the Ohio Secretary of State correctly reads the statute and applies it using the fact that people didn't vote as the primary factor for why they were removed from the rolls. The practical implication here is that Ohio can purge a lot of voters. They can, after 2 federal elections, go in the voter list, and with little more than the fact that people didn't vote in those elections, send them a postcard. If they don't get the postcard back, kick them off the voter rolls. This is significant for a couple of reasons. It's significant, one, because Ohio doesn't have same-day registration. So if you're kicked off the rolls and you don't find out until you show up to vote, you can't be, you're not going to have a chance to vote. And 2, Ohio is a swing state. And so a lot of litigation goes on in these swing states because they're so important in our presidential elections. And Ohio is a big swing state in the Electoral College. And so there was a lot of attention on this case from the voting rights community because the fear is that other states will follow Ohio's lead and use this to purge voters from the rolls, maybe when the voter simply didn't get the postcard or ignored the postcard, but didn't vote in 2 federal elections. So luckily, we're seeing some trends working against states like this. One trend is that a lot of states are adopting automatic voter registration, like Rhode Island did with Common Cause and the ACLU supporting it. And that automatically updates your address when you change your driver's license. And then we're seeing, increasing number of states adopt same-day registration. Unfortunately, Ohio hasn't done either of those 2.
No. And moving along, the time is starting to get short, so hopefully we can review these kind of quickly. There's actually a win in this session. Carpenter, Dick?
Yeah, Carpenter was a 5-4 decision reversing a 6th Circuit Court of Appeals determination where the court below denied a motion to suppress cell site location information that was gathered through a court order, but not by way of a warrant. The court held in Carpenter that you needed a warrant to access cell site location information.
Cell phones.
No, cell site location information is the information that is created every time you make a call. Okay. Your call goes out to a cell tower, and that information of where that signal went to from your phone number, and that signal is recorded, and it's retained. And by that, you can approximately locate an individual's location at any given time, particularly if make more than one call and they're all in a particular area, you can triangulate it or whatever. And the court used that in that particular case to show that this person was in a particular location where these robberies occurred, and they used that against him. This decision is interesting in that the Stored Communications Act allowed you to get access to this through a court order by just showing reasonable cause to believe that it's material and helpful in an ongoing investigation. Of course, the probable cause standard is more than that. You need probable cause to believe that a person is committing or will provide evidence of a person committing a crime or about to commit a crime. So it's a higher standard. So the court opted for the higher standard. It's a win for civil liberties. I will only say it is also consistent with recent decisions in this area. It's a combination of the Riley case, which says that your cell phone data is protected and you need a warrant to access that, and also with the Jones case, which putting a GPS locator on a car is something which also requires a warrant. Again, that there's a privacy interest in your location, a privacy interest in your data, sort of a combination of those two cases. So it's consistent, flows from it. It's a 5-4 decision. It's a win.
This year. Moving along. Gerrymandering, John. I don't know where this case came from, but this was a loss.
Yeah, well, it was a wash, but it will be a loss in the end. So it was sent back to the appeals court because of lack of standing. But the reason it'll be a loss is because all the hope for dealing with this case rested on Justice Kennedy, who just announced his retirement. So 14 years ago, there was a case dealing with partisan gerrymandering. And this is the idea that political parties gerrymander districts, legislative and congressional districts, in a way to advantage their political party, so that even if, for instance, one party wins a majority of the vote, they might not win a majority of the seats in the legislature. The Supreme Court has never ruled that partisan gerrymandering is unconstitutional under the First or the 14th Amendment. There was a lot of hope because 14 years ago, Justice Kennedy wrote a decision in a case called Bandemere, suggesting that someday perhaps the court would rule against partisan gerrymandering, if only a good measure of partisan gerrymandering could be found. So law professors, political scientists spent 14 years trying to tee up a perfect case for Justice Kennedy and Justice Kennedy alone. And they developed a whole body of social science around something called the efficiency gap, which is a measure of what are called wasted votes. So how many votes are wasted by people who vote for a political party, but those votes don't matter for control of the legislature. This case comes out of Wisconsin. People are familiar. When the Republicans took over the Wisconsin legislature in 2010, they redid the districts for the state legislature in such a way as to really disadvantage the Democrats. And so some Democratic voters sued Wisconsin and said those districts were unconstitutional under the First and the 14th Amendment, so under free speech and an equal protection claim. And they got it to Justice Kennedy, and they thought they would have him because he loves the First Amendment, or his view of the First Amendment. And he suggested they can come up with a measure. And they thought they had that measure in the efficiency gap. And 9-0, they said that the plaintiffs don't have standing here, or didn't establish standing, because, and it's somewhat technical, but essentially they were challenging the maps as a whole, statewide, not the maps of an individual district. And so they said, you know, the injury is to the voter in their district, not to the voter in the whole state. And so they sent it back, they remanded it to the appeals court. It may get called back up to the Supreme Court. There was also a case out of Maryland that dealt with an individual district that got sent back for lack of standing right now. And there's a case, Common Cause versus Runcho, out of North Carolina, that's already been put on the docket for the fall. So there's still some hope that they'll deal with partisan gerrymandering, but Justice Kennedy's absence really dims that hope because he was the swing vote on this issue.
We have about 3 minutes. Dick?
Yes.
And we have Epic Systems.
Epic Systems was a 5-4 decision wherein the Supreme Court ruled that it was not a violation of the National Labor Relations Act right to concerted action provision for employers to require employees to sign arbitration agreements whereby they waive the right to class and collective actions under the Fair Labor Standards Act, wage and hour claim violations. It was basically decided on statutory construction. It just said that the right to arbitrate or the obligation to enforce arbitration agreements, which is a contract, is not trumped by the concerted action clause of the National Labor Relations Act because the concerted action clause just applies to organizing and collective bargaining, and they want to construe statutes statutorily to be harmonious and not basically overruling the other if they could avoid it. So it was more a statutory construction case, not a win for workers. A lot of wage and hour cases don't involve a lot of money. Workers are not going to bring it unless there is, and lawyers are not going to bring it unless there's a pot of money, a collective action, and class actions are ways to vindicate these wage and hour claims. So it's a loss, but a narrow one on statutory construction. I will only add that they overruled the NLRB's interpretation of the concerted action provision. The NLRB said you can't have an arbitration agreement overrule the concerted action provision. They didn't give it chevron deference and chose to pursue the statutes harmoniously.
On that note, it's time to grade the Supreme Court for the last session on civil liberties issues, non-immigration. A to F.
Oh, yeah. I mean, so certainly on the voting rights, I would say it was a C plus at best.
Great inflation.
Yeah, if only because they left the door open on the gerrymandering to live another day, but it's not looking pretty.
It's a tented in pencil, a C plus. Dick.
D, but I include the Janus case where the Supreme Court held that public unions cannot require agency fees to those who choose not to join the union but get all the benefits of it. So including that, it's a D.
And I give it F minus based on a minor win and a bunch of losses. But I'm not the grader in this case. Our time has gone. And we got the 5 cases in. Next month, we will look at immigration cases that came up this session. Maybe we'll pick up on the Janus case involving public sector unions. Thanks for tuning in. If any of the issues we covered today are of concern, our contact information is on the screen. John Marion, Common Cause, thank you.
Thank you.
Dick Sinapi, old buddy. Law offices in Warwick, check them out. Thanks so much. We'll see you next time.